Good morning, Jackie. How are you doing?
I'm doing fine, thank you.
I'm honored that you have agreed to do this oral history. I've known you since I've started practicing law, and I've always been inspired by a lot of work that you've done and your attitude. And could you, just to start with, tell us something about how you decided or why you decided to become a lawyer.
I was majoring in psychology at the University of Colorado. I was graduating in 1971, and I knew with a certainty that I did not want to go any further with psychology. I thought that clinical studies and research was way too demanding of patients. And I knew at that point that I didn't have the patience necessary for either research or clinical work. So I needed something that I thought would be shorter, like using my psychology skills, but shorter in terms of my interactions. And I ended up, after doing some work in legal aid, going into public defender. And that's where I thought that the cases would be shorter and that there'd be a beginning, a middle, and an end to my cases. And what I discovered throughout the years is that there was a beginning and a middle, but there was really no end. And I liked that. So the reason that I went into law was to get away from the psychology, which I never really got away from.
Right. I mean, that's one of the reasons why I like criminal law, is because of the psychology of the jury, the courtroom, clients and stuff. You did most of your work, most of your career, that spanned, 40 some odd years?
45.
45 years, wow. In criminal defense, in one way or another.
Right.
And at one point, you were in the public defender's office as an assistant public defender, but eventually you ran the entire public defender department for the state of New Mexico.
I was the chief public defender.
And how long did you hold that position?
5 years.
Okay. I would imagine that's a lot different, being the chief public defender for the state of New Mexico, than being a line attorney and taking cases to trial and representing defendants.
Well, I tried to combine them, and that was one thing that it got me investigated by the state bar. And I was told that I was no longer going to be able to represent people and to be the chief public defender at the same time. So actually, it was a blessing in disguise. What happened?
Excuse me, what was the reasoning for that?
What happened was, when I became chief public defender, there was nobody that was really handling the habeas cases, which would be the post-conviction cases attacking the conviction. And so I said, well, I would take over those post-conviction cases. I was in the Santa Fe office, and that I would contact my clients and figure out what was happening on their cases. Well, after I contacted them, I then went into trial with John Bogren and Tom Jameson, and we represented Darcy Pierce.
Okay.
And
And that was a very high-profile case.
That was a high
in the
profile.
80s or 90s?
That was in the 80s.
Yeah, okay.
And as a result of notifying my habeas clients, that I would not be able to respond to their questions for about 6 weeks, because I was giving myself 6 weeks in the trial. I said that if they had an emergency, they should call this number and somebody would take care of it. But otherwise, I would not be able to work on any of their cases, along with being chief public defender and representing this defendant. And one of the clients complained, one of the habeas clients complained, that I had abandoned him. And I was thinking, how could I have abandoned him? But what happened at that point was that there was an investigation that was done by then attorney Charlie Daniels,
Okay.
who then became a justice on the Supreme Court. But at that time, he was still an attorney. And he investigated the public defender, and it turned out that I should not have volunteered to do that case because we had a systemic problem of ineffective assistance. And he recommended that as a result of his investigation, that I should actually ask for the money that we were lacking. And if I didn't ask for that money, then I was in danger of losing my bar card.
Wow.
So
Okay.
I asked for the money, and the legislature on that year gave me a 40% increase in funding.
Wow.
It was a phenomenal increase.
Okay.
And as a result of that, it's like, be careful what you ask for, you might get it. We had all sorts of problems
Right.
in terms of the things that we hadn't asked for that we needed as a result of getting what we had asked for.
Right.
So everything came out just fine in the end. It really was an improvement for the public defender. It was an improvement for me. But as a result of being told that I could not represent people and be chief public
Yeah.
defender, I quit representing people individually.
Yeah. Now, I can't imagine, I worked in the public defender's office for a time, absolutely loved it. That was, the best job ever. But it was always a lack of resources.
Right.
You have 60 or 70 clients, half of which are in jail. You're in trial half the time, or back then we were in trial half the time, and you can't get to the jail, and it's just constant. I bet you could work 20 hours a day, 7 days a week, and still not do all of the work that you need to be doing.
I felt that, but we had a saying at the public defender: if you've only got 5 minutes for a public defender case, make it a good 5 minutes. And that was the way I felt that we got the most out of it. And a lot of times I think that we can use understaffing, under-resourcing as an excuse. And that if you need something, you complain about what you need, you work it through the channels, you take it to court if you have to take it to court, but one way or another, you make a difference.
Right. And I do think that the public, even to this day, I tell people, public defenders are some of the best attorneys around, because that's all they do. They know the judges, they know the system. And I think back then, excellent, criminal defense attorneys.
Well, one of the cases that I was looking back on was the case of State of New Mexico versus Robert Young and Reyes Lopez and the Office of the Public Defender, the real party in interest. And this was a case where I had stopped being the chief public defender. I'd gone back into private practice, and then into the private appointment. And I was appointed to represent Reyes Lopez as a death penalty case. And it wasn't that I felt that I was particularly adept at death penalty cases. I remembered that I had heard a speaker say that if you had a true death penalty case that went to trial, it was a failure of negotiation. So I took that to heart, and I decided that I was going to try to negotiate with any death penalty case that I had. And in the end, I ended up negotiating on this particular case. But the way that it came about was that we were being paid a flat fee to represent these clients. on the death penalty, and it was found by the New Mexico Supreme Court to be, it says, all parties agree that this is one of the most complex death penalty cases ever tried in New Mexico. Indictments were filed in May of 2000, and present counsel were appointed in June of 2000. The state filed its notice of intent to seek the death penalty in November 2000. There are 15 named defendants, although the state seeks the death penalty against only 3, Young, Lopez, and David Sanchez. Defendant's motion asserts that the state listed 128 witnesses and provided over 160,000 pages of discovery through various media. It then goes on to talk about the exact fees that we were being paid, etc. And the fees were flat fees. And the Supreme Court says, we are persuaded by the evidence in the records that the attorneys for the defendants are not receiving adequate compensation. The inadequacy of compensation in this case makes it unlikely that any lawyer could provide effective assistance, and therefore, as instructed by the United States Supreme Court, ineffectiveness is properly presumed without inquiry into actual performance.
Wow. And what were you being paid? I mean, what was the typical fee? As I recall, it was around $5,000 for a death penalty case, or maybe $10,000?
No, actually, it says the original contracts provide for a maximum of $19,500 through trial for each first chair attorney and $9,500 for each second chair. These fees were increased several times over the course of 5 years, ultimately offering an additional $27,000 for $46,500 total for each first chair attorney and $12,500, $23,000 total for each second chair attorney. Counsel have not signed the amendments offering the higher fees and thus have received no payment beyond the initial contracts. The contracts have expiration dates and have in fact expired, but the contracts require counsel to continue representation until the cases are concluded. So then they talked about what they were trying to get in terms of appropriations.
And that's often, I mean, the case when you've got people, I know that Gary Mitchell, represented, and some attorneys are known for being involved in death penalty cases. And it's well known, and they accept the fact that they're going to spend hundreds of hours on these cases, if not thousands, and they're going to be losing money. And they do it more because they're dedicated to the cause than earning an income.
Well, that was part of the question that we presented to the court, because we said that either the court should allow us to withdraw and appoint other attorneys. The public defender looked, The public defender could only find one attorney in the state of New Mexico who was not conflicted out and who was willing to take the case. And that was not going to be the answer for the two of us, getting out of the case. And so we were saying that either the public defender should allow us to withdraw, or they should get the money so that we would be paid an hourly rate, or they should the court should dismiss the death penalty.
Okay.
And as a result of the chronic case being applied to this case, the Supreme Court Basically what happened was the Supreme Court said that if the legislature appropriated the amount of money that I had presented to the court in terms of what needed to be done, then what I had ended up presenting to the court was that it says the most detailed analysis was provided by counsel for Lopez at the June 27th, 2005 hearing on the motion to reconsider. Counsel estimated both she and her co-counsel combined would spend a total of 2,334 hours from termination of the original contract on November 1st, 2003 through the end of trial. If the contract amendments and additional 100,000 are applied just to the 2,334 hours as counsel suggested, then the effective hourly rate would be somewhere between $43.84 and $60.20. Counsel calculates the overhead rate for her office to be $73.96 per hour.
That's just crazy. And in essence, were you involved in the repeal of the 2009 repeal of the death penalty?
Well, I was involved in terms of doing this case, and this case was decided October 25th of 2007.
Okay.
And so what this case did was it said, legislature, you can decide if you are going to give the defense counsel the amount of money needed to defend a death penalty case. If you decide against it, then the death penalty cannot proceed. So the death penalty was stayed during this amount of time. The case came down in October. The session of the legislature was started in January. And by the end of the session, the legislature had not appropriated the money. So it's the only time that the Attorney General office has conceded. They conceded that they could not proceed with the death penalty, and the death penalty was dismissed.
Wow, and I mean, that's huge. And I think that was a big argument, and that resulted in the repeal of the death penalty, is we don't have the money. Forget the moral issues of, is it the right thing to do or the wrong thing to do? We don't have the money to do it, to proceed death penalty on these cases.
I think it was a combination of the two.
Okay.
I think that there was a reevaluation of whether we wanted to have the death penalty, and that is in Justice Daniels' special concurrence.
Right, and you're talking about the Robert Fry and Tim Allen case.
That's right.
And that was one of your last cases. And tell us a little bit about that case, because that was a phenomenal result. But I think a very just result.
I think it was a wonderful decision by the Supreme Court, and it happened to come down on my very last weekday in my office. So on June 28th of 2019, I had 2 days over the weekend to get the office cleared out and close my office downtown in Albuquerque. And the Fry decision came down on that date, and I considered it to be a wonderful conclusion to my career as a criminal defense attorney.
To your many years in practice. And tell us a little bit about that case and why it was so important and why it was such a good way to go out of your practice, to retire.
Robert Fry had been convicted of 4 different cases involving life sentences or death penalties. And one of the things, so this case was, I believe, the first case that was tried against Robert Fry, and it had resulted in the death penalty. The death penalty had been affirmed on appeal. Kate McGarry was appointed to represent Mr. Fry on the post-conviction habeas case. And she was proceeding with co-counsel, and I believe I was talking to Kate over the phone, and she was saying that she no longer had her co-counsel, and could I help her decide on another co-counsel. And so I was suggesting all sorts of names, and she was saying, I've tried that person, I've tried that person, I've tried that person. And I was saying, well, I think you've tried everyone that I'm suggesting. And she said, you haven't suggested yourself. And I said, oh, you don't really want me. I'm not an appellate attorney. And she says, I can do the brief, I can do the appeal, but I'm not the trial attorney. Mm-hmm. And she wanted someone who could help her out in the trial that they might have to do on the habeas. Mm-hmm. And I kept on voicing my disinclination to be part of this, because I didn't think I was what she needed. But she nevertheless convinced me that I was what she needed, at least at this point, and that there was no one else for her. So I took over the case, and I was second chair. So she was always going to write the brief. Any briefing was going to be written by her. I argued the case in the trial, before the trial judge, and I argued it on a motion to dismiss the death penalty in light of the repeal. And the repeal was prospective only, meaning it went from July 1st of 2009 forward. It did not apply to either Robert Fry's case or Timothy Allen's case, which had been tried and convicted and sentenced to death prior to the repeal of the death penalty. So we had raised 3 grounds for the dismissal of the death penalty. One was cruel and unusual punishment, the other was equal protection, and the third one was a violation of this rule against special laws, that you cannot apply special laws to get particular people. And I want to give a shout out here to one of the people that assisted me, and it was Jessie Miles. Jessie is now an attorney in her own right in El Paso, Texas. She does immigration law in ground zero of immigration law. And but Jessie came and she shadowed me, and she said, I want to shadow you. And I said, I think that's fine, but tell me what a shadow does. So she explained to me that she just followed around in my shadow. Yeah. And she came to a hearing that I had on Reyes Lopez's case, another one of those misnomers in terms of, I represented Reyes Lopez initially on the death penalty case, and I filed a habeas as part of that death penalty case to attack the underlying conviction which had taken him to prison. And when the death penalty was resolved on that case, he was then allowed to plead to second-degree murder plus other related charges. And as a result, I then pursued the habeas case. So one of the hearings that we had was in Grants. And so Jessie had to come out to Grants in her own car because for some reason she couldn't carpool with us. I think it had to do with timing. And she came back, and then we discussed it, and she said, well, I'd really like to work with you on one of your death penalty cases. And I said, well, that at that point I didn't have a particular use for her work on Reyes Lopez's case, but that I had a motion that we wanted to file on Robert Fry's case. And she volunteered to do that motion. She didn't get paid for doing it. And later, after she had done most of the bulk of the work, that's when she got paid for doing some work on it. But initially, she was a complete volunteer. And she regarded it as the best thing I could have done for her. And I regarded it as possibly the worst thing I could have done with her.
Yeah.
Because I saw it as asking somebody to do a motion that we did not have time to do at that point. And so if we had done that motion, it would have been notice pleading, we would have argued it and seen where it had gotten us. She did it, and she did immense research. She did all the state interstitial analysis so that you could say that we can't get any relief in the federal courts, but we can get relief, and we should get relief in the state courts, why we should get that relief. She'd done all of this research, put together the entire motion. She would come to me in my law office, and we would sit together on Saturday afternoons and go over what she had done and what she needed to do next. So this motion that ultimately went up to the Supreme Court is Jesse's baby. And I want to give a shout out to Jessie that I could not have done it without her.
Well, that's nice. And she's still doing good work down in El Paso.
Yes.
But basically, the Robert Fry and the Tim Allen case, what's the bottom line on that case?
The bottom line is, it says, in this consolidated appeal of the district court's denial of petitioners' motions to dismiss their death sentences, we hold that petitioners' death sentences are disproportionate and violate section 3120A-4C4, guided by our recognition that our legislature intended for comparative proportionality review to protect against the arbitrary imposition of the death penalty. We conclude that there is no meaningful basis for distinguishing Fry and Allen from the many similar cases in which the death penalty was not imposed. Because petitioners' death sentences are statutorily disproportionate to the penalties imposed in similar cases, we remand each case to the district court to impose a sentence of life imprisonment.
Okay, so these are two individuals that got the death penalty before the 2009 repeal, and you asked for a dismissal of the death penalty based upon the grounds that it basically was granted.
But let me say something about this,
okay,
because this was not what we mentioned nothing about the state statute. We were doing a constitutional argument.
Right.
So everything that Jesse researched for me was constitutional. The Supreme Court, in its wisdom, asked for supplemental briefing on whether these sentences were disproportionate and whether the court should reconsider its holding in State v. Garcia, which had given the parameters that the court would use in terms of comparative proportionality. And the court decided that they would no longer use the traditional approach to proportionality that they had adopted in Garcia. The court modified that approach, and the briefing was done completely by Kate. My contribution to this effort was to do an appendix. I'd never heard about an appendix. I'd never done an appendix before. But my appendix was 21 pages of single-spaced typewritten pages of decisions that we had made throughout the pendency of the proportionality argument that related to how we were restrained and limited in our research. And one of the things that the Supreme Court decided was they said, additionally, there is no central repository of information regarding death penalty cases, making it difficult to obtain the details and records necessary to thoroughly conduct the comparative proportionality review. As Fry and Allen note, quote, the legislature obligated this court to conduct a proportionality analysis, but failed to provide any mechanism to collect the cases that could be used in the analysis, unquote. Unlike other states, New Mexico does not collect data to support comparative proportionality review. My appendix, that is a little summary of my appendix right there, because that's what I was showing, was every time we decided that we needed some information, we were thwarted by the lack of a central repository for these cases. So my contribution to this brief is that we couldn't do it, and if they were going to say that it was our obligation, because that's what was said under Garcia, then that was a violation of due process because the state of New Mexico had not collected the data.
And the bottom line, if you read through the case, which I have done more than once, is they go through, they're basically looking at this defendant is charged with this crime and these are the circumstances. He received the death penalty. This defendant is charged with these crimes under these circumstances, and he didn't get the death penalty. And this person is, and you're trying to make sense of why it's given in one instance and it's not given in another instance, and what is fair, and if it's not fair, it's disproportionate, and what a DA in Clovis may make a different decision on a less heinous case than, say, the DA in Santa Fe. And how can that be fair, and how can we justify taking someone's life under those circumstances?
I think that Justice Daniels, because by the time that this case came through, he was on the Supreme Court, he said in his special concurrence, but when the collective result of all the actions taken under authority of our state justice system is that one or even three cold-blooded murderers out of hundreds are executed by the state, while the equally culpable majority are spared, our state cannot honestly claim it has imposed the death penalty in a proportionate manner. A killer's crimes reflect who he is. What we do to the killer reflects who we are. Can we really look anyone in the eye and say that executing these two defendants would be proportionate when compared to non-deadly punishment our state has overwhelmingly meted out in virtually all equally serious first-degree cases, and specifically in similar cases since enactment of the Capital Felony Sentencing Act in 1979. I, for one, cannot honestly do so. I concur in the judgment of the court.
Okay. And do you consider this one of your biggest victories as an attorney in your many years of practice?
It turned out that way.
Yeah.
And I just think that it's very funny how I got involved in the case. My total contribution to the appendix on the case, and the fact that it takes an entire team to represent somebody. And I think you see it most obviously in death penalty cases, but it's in every case. It takes a team of people to gather the facts, make the facts presentable to the court. I'm very proud of the records I was able to make and the record of the appendix where I was not able to bring the facts in front of the court because we were thwarted at every turn. So I see, the importance of investigators, the importance of mitigation specialists, particularly in death penalty cases, but in other cases too. It's important to give the court a choice. I feel like we gave the court the right choices and the court made the right decision.
That's a good feeling, isn't it? When it's more than a job. I mean, you're really doing something you believe in, and that's essential for the betterment of our legal system, our society.
Well, and I think today is the day that the Senate may be voting on the nomination of Ketanji Brown Jackson.
Okay, you did good on that. Well, and I was going to bring that up because she has been looked down upon for her job as a criminal defense attorney.
Yes.
And that has been used against her. And I think someone on the Senate Judiciary Committee even said, our children will not be safe in America if she's appointed to the Supreme Court, the United States Supreme Court. And I'm just aghast at that. But a lot of people will believe that. What is your opinion?
I am really proud of her nomination.
Yeah.
I'm really proud of the way that she came through, in my opinion, with flying colors, through her nomination hearing, her confirmation hearing. And I'm very hopeful that she will be voted onto the Supreme Court bench. And she'll be the first public defender who has been appointed to the Supreme Court.
And if you don't acknowledge the necessary role of a criminal defense attorney or a public defender, then what happens to our criminal justice system?
I think it is always a question of the tension between the role of the adversarial system. Mm-hmm. And you were the district attorney, you're now a defense attorney. I think that you injected fairness into a system that could obviously skew to the other side. And I think that's what I tried to do. Mm-hmm. And I think that's what any good public defender tries to do, is tries to make the system fair. I cannot guarantee any results from trial, but I can say that the trial will be the fight. And that if we go down fighting, we go down well. And that's why I wanted to make my record, because I never took any results as guaranteed. I always was like trying to present the defendant's side of the issue, trying to question the evidence from the defendant's point of view, and making sure that if the defendant had nobody else, he had me to stand up for him.
And I think any good prosecutor will say they want a very, very strong defense attorney. They don't want to be worried about the defendant getting a fair trial or being adequately represented. And only do you get justice when you have both sides that are fighting for what they believe in, presenting the evidence, and that a jury can make a decision on.
You're reminding me of a phone call I once got from a federal prosecutor who shall remain nameless. And he called me up and he said, "Are you death qualified?" And I said, "Aren't we all?"
It's going to happen to everyone.
And what he was getting at was that was I qualified under the federal system to handle death penalty cases. And under the federal system, and actually under our state system too, you have to have tried a death penalty case through the death penalty stage in order to say that you are death qualified. I have never tried a death penalty case. I have always been able to negotiate the death penalty away, or to have it like on Reyes Lopez's case, to have it done away with by the Supreme Court. Once that was done away with, that's when the prosecution offered us second-degree murder. It was never on the table before. I think it is really important to be able to say that I'm not death qualified because I've been able to negotiate every single death penalty.
And truth be told, I think most defense attorneys feel it's a victory if you get the death penalty off the table for your client.
If your client is, in fact, guilty.
Right.
You know, there's always the case, and I think Gary Mitchell has had cases where he got an acquittal on a death penalty case. And that would be a real cause for celebration.
Right, that's worthwhile. So, I mean, you've retired and you look back on your career, and I mean, obviously the Fry case was a huge case. You've had many cases that were huge. Are there any others that stand out in your mind as defining times, defining decisions in your career?
I've had a number of cases that, you know, for one reason or another, they stand out to me. And I've also had particular clients who've maintained contact with me. And those matter too. Sometimes the defendant is still in prison. Sometimes they're out and they're doing well. You know, I've had, you know, just what I consider success stories. Two success stories had to do with Delancey Street, which is a program up in Espanola, Alcalde, New Mexico. Each defendant, of these two, each defendant told me, don't get me out of jail. I know I will go back to drugs. I don't want to do that. I want to go to Delancey Street. And so I got them into Delancey Street as part of their probation, and they were able to go directly from jail to Delancey Street, and I had my investigator pick up the defendant at the jail and deliver him to Delancey Street. And they are the success stories. Each one of them has succeeded in their career. They finished the program at Delancey Street. They stayed on for extra time so that they could become the people who decide who gets into Delancey Street. And then after they left that program, one became a social worker, the other one went into water management. I think it's wastewater management. And they're successful, they're constructive, they're law-abiding citizens at the present time, and they show that, for me, they show that there's a reason for hope.
Yeah, and I think that sometimes the public's perception and everybody's primary concern, in poll after poll, indicates fear of safety and the issue of crime, but they think defense attorneys get people off. They get guilty people off. And they don't see a lot of the positive things, like you mentioned with these two clients, and the positive difference. And I always like to say you're an attorney at law and you're a counselor at law. And the counselor is real important, probably in all kinds of law, but certainly criminal defense.
I think it is, and I think that, you know, a lot of the work that we do, especially in federal court, is plea negotiations, plea bargaining, pleas. And, you know, at the present time, the guidelines in federal court have, you know, you could either say it's a bonus for pleading or it's a tax on a trial. Either way, if you lose at trial, you get an extra bump of 3 levels. So that's a major consideration. And what I don't want is for somebody to plead guilty if they are not in fact guilty.
Right.
That would be an Alford plea if Alford pleas were allowed in all federal courts.
Yeah. And I'm sure some people do plead guilty when they're not guilty, because it will take less time, it's more efficient, and they can get on with their lives quicker than if they don't. And that's not appropriate, obviously, but it happens.
It happens. And, you know, that's what I would like to avoid, if at all possible. That's why if somebody really didn't do the crime he's accused of, then I want to be able to prove it to the satisfaction of the prosecutor.
Right.
So that we can get those charges dropped.
Right. Looking back on your career, do you have any regrets?
No.
Isn't that amazing?
I don't think I have any regrets. I'm really glad that I was able to close my office down, make my own decisions, and that I was able to tell the people at New Mexico Criminal Defense Lawyers Association the reason that I was retiring. I told them that I no longer had the stamina. And you need stamina in order to be a good defense attorney, because you need to be able to fight. And I knew I didn't have it, and it was time to go. And I've worked with amazing people who are now lawyers in their own right. Angelica Hall used to work with me as her own. She was her own attorney. We both had separate practices, but I hope that I got her started right. And she is now a federal public defender. There's another woman that I worked with, Haley Lisha, and Haley worked with me on a trial that I did in federal court. And she would come up to me every day after she had managed to make it so that she could watch the trial during the day and then go to my office at night and say, what do you want me to work on now? And that was just wonderful.
Yeah.
So Haley is now an appellate defender in Baltimore County, Maryland public defender. Then there's Kat Harris, who worked with me on the Fry case. She was still in law school at that time, and I asked her, she had been a paralegal before, and I asked her if she would help us compile the cases that we would need to compile for the proportionality review. Well, she educated me on how we couldn't do what we were trying to do because we didn't have the information. And so I was able to put that in the appendix. She is now a public defender in Newport News, Virginia. So I feel that these are some of the people that I've worked with over the years. And there's one part of me that says, they looked at me and they thought, if she can do it, I can
do it.
Yeah, I can do anything. Yeah, but I think there's also a very warm feeling that I get from knowing that they saw what I did, they liked the way I did it, they are trying to emulate it in their own ways. And I think they are holding that torch up high.
Well, and you point out something I think that's really critical, and that is that we mentor younger people. And if we truly believe in what we're doing and the value of what we're doing, then we have that obligation to mentor others, and so they can continue on the good work. Who were your mentors when you first started out?
Well, I think that we're going back to law school now.
Yeah, or wherever, wherever you want to go.
You know, I didn't have many role models particularly as a defense attorney, but there were women who were practicing law, and I think that our class had 18 women and 100 men, and it was the class of '74. It was a very raucous class. And I was at UNM Law School. And I believe that Dean Hart, may he rest in peace, decided that we needed women law professors to help us. And he was very much into mentoring. And so we had Ann Bingaman and Pam Minsner teaching us. And they were great.
Yeah.
And I recall that, you know, when I came into law school, I came in with a background in consciousness raising. And so I just thought that there was going to be a fight, and we should prevail, but it wasn't guaranteed. And Ann Bingaman and Pam Minsner, I think, taught me how to fight.
Okay. Well, that's great. Is there anything else you want to say in wrapping up? But thank you so much for giving us your time. And hopefully people will, it's always inspiring to talk to people that have made a difference in our profession. Because sometimes that's all we have, are looking at people who can inspire us. Some days are bad days, rough days. Decisions aren't always what they should be, but we persevere.
I think the perseverance is a really important part of it. You know, I kept some of the letters that my clients had sent me, because I think that they're really important to pull you out of a funk on a bad day. It's what allows you to persevere.
Okay, well, thank you so much for your time, and we'll call it a wrap.